Ladies and gentlemen, without further ado, longtime friend of the Big 550 KTRS, longtime friend of mine. Good morning, Ed Dowd.
Good morning, McGraw. How are you today?
Good. In terms of full disclosure, I believe you are my attorney. I think I gave you $1 and put you on a retainer at some point. So you are my attorney as well.
No question.
Okay, good. Also, in terms of full disclosure, your son, Andrew, longtime friend of the show, was one of our producers here for a long, long time. So you and I go back a long ways.
That's exactly right.
All right, good. So get that out of the way. Now, let's start with the news of the day, and that is yesterday, I guess there was a bit of wrangling in court, and the story is that you think the prosecution is hiding evidence. Why do you think they're hiding evidence?
We don't know that they are, but they've given us, until yesterday, they had given us absolutely nothing, and now we're trying to find out what happened in the grand jury, what evidence was presented there, what witnesses were there, and I think we're entitled to all of that.
Have you gotten that yet?
No, we have not. We don't have any grand jury information. We're asking, and we're entitled to, under the rules of criminal procedure, to the testimony of the witnesses in the grand jury. And yesterday, the circuit attorney's office was saying, well, yeah, we can get those for you, but it'll take 4 weeks, which is absurd. You know, we get those in our trials. We get the transcripts of the full day's testimony that night so we can be ready for the next day. So there's no reason we shouldn't get those tomorrow or the next day. And I'm sure the court reporter would be happy to do that for us, but apparently the circuit attorney doesn't want us to know what's in that testimony.
Yeah. You want a quick trial or a quick trial date. They want a longer trial date.
Right.
You also want a jury trial. Just in terms of strategy, what's your reason for wanting a jury trial?
Well, we generally always want a jury trial. We have Jim Bennett and I and the rest of our team have tremendous confidence in juries that they will do the right thing under the circumstances, and we have really proven that to be true over and over again, and we just have a lot of confidence in juries. We think they do the right thing. I think judges do too, but we're going to give a jury a chance to acquit Governor Greitens.
There are a number of fronts Governor Greitens is taking incoming in, and that is down in Jefferson City, and of course this indictment in the city. Are you dealing at all with what's going on in Jefferson City?
Not really. I will be, and I will be, I'm sure dealing with the House members who are looking into this issue. We have not really had much contact yet, but I think in the next 30 or 40 days we will.
Do you think Governor Greitens will be asked to testify in front of this House committee?
I don't know. We've never even gotten that far. Generally, the first focus here is the criminal trial, and that's what this is all about. That's why when we were in court the other day, we were saying, Your Honor, the circuit attorney indicted our client on a felony, which we think is completely wrong in every respect, and now we want a trial. We want a trial in April. We wanted a trial in 6 weeks from when we were in front of the judge, and the judge decided that it would be fair to have a trial setting on May 14th, which is not as close as we wanted because there is so much going on. As you say, McGraw, there's so much going on in this state, and he needs to get back and be the governor of this state. And the circuit attorney's answer was, well, we want a trial in October. And they said that again yesterday, that they want a trial in October. Well, when you indict a case, and as you know, I was the U.S. attorney here and assistant U.S. attorney for about 12 years. When you indict a case, you've got to be ready to go. You don't indict a case, especially of the governor of the state, and just throw a monkey wrench into the whole operation and then say, we want to get around to this when we've got time in 8 or 10 months. I just don't think that's fair at all.
No, I agree. Actually, I think sooner the better for everybody. Do you expect Governor Greitens to take the stand in this city trial?
That's a decision we always make during trial. I wouldn't be at all surprised if he did, but I've had criminal trials where people didn't testify and the jury couldn't wait to acquit them because, if the state doesn't make their case, there's no reason to put anybody on the stand. But I think even more importantly than that is I think there's a very good chance there will never be a trial in this case because our motion to dismiss really lays out very clearly that this statute that he's been charged under doesn't cover this conduct. And we still have a lot of issues about the transmission aspect as well, that whether that's, I don't think that's what, I think they haven't told us what they think the transmission is, but I don't think it's going to be sufficient to make this a felony. This should have been a misdemeanor, and it really shouldn't have been anything because the conduct is not covered by this statute.
Okay, Ed Dowd, attorney for Eric Greitens, make sure I understand you correctly, that you have an issue with the transmission issue. Are you admitting now that there is actually a photo or was a photo taken?
No. Once again, that's a trial, that's a tactics and strategy issue that we'll decide what to do with that issue when we get closer to trial, and probably not until trial.
So Jim Bennett was quoted in the St. Louis Post-Dispatch back in January that there was no photo. Now your team is saying you're not going to answer the question. I mean, I understand you're a world-class lawyer, but for those common minds like myself, can we assume that there is a photo because you're not saying there's not a photo?
I wouldn't assume it because that's a decision that we're going to talk about that at the time of trial, and the effect of whether there is one or not.
Okay. So you're not confirming or denying there is a photo?
No, and the important thing about that is that the photo doesn't even matter in this case because there is this conduct where two consenting people get together and disrobe so that they can be viewed sexually is not a crime under this statute.
Certainly understandable. And let's get into your reason to dismiss. Explain, because I don't want the filter of the media and everything else to get in the way. I want people to know from you directly, what is your reason for a dismissal of this case? What's the argument?
Well, the statute says that you can't have a reasonable expectation of privacy, so the statute would apply. The person, the alleged victim, would have to be in a place where they have a reasonable expectation of privacy. And that is defined as a place where a person could disrobe in privacy, which obviously didn't happen here. They were disrobing together without being concerned that the person's undressing was being viewed, photographed, or filmed by another. This definition knocks this case out by itself. That, you're disrobing, you're not private, you are concerned that the person's, that you absolutely know you're being viewed for sexual purposes.
So you're saying because two people are disrobing together, everybody loses their expectation of privacy?
If you're doing it for sexual pleasure, that's what the statute says. And that's all I'm doing is reading the law and discussing how it applies to this situation. And as you can hear, it's very clear.
Right, but if there is a picture taken against one's will, somebody says, no, I don't want a picture taken, does that person have a right to privacy to say, no, I don't want a picture taken?
If you're in a place where you don't have a reasonable expectation of privacy because you're disrobing and you know you're being viewed and it's for sexual gratification, you don't have a way of having a person prosecuted under this specific law. That doesn't mean that I don't know if there are other laws that cover it, to tell you the truth, but that doesn't mean you could of course sue someone for that. But and that's one of the other weird things about this case is this is a 3-year-old event where there was never a complaint by the alleged victim. There was as Governor Greitens has admitted to, there was a course of conduct here from March on for some months, and this was between two consenting private adults 3 years ago. She never called the police. She never called the FBI. She never complained. And then 3 years later, her former husband started complaining, and the circuit attorney decided to make something out of this. Well, they don't have a statute that applies. And I said that at the time when this first came out. I said, I can't imagine any prosecutor would really waste the time investigating a private tryst between two people.
Well, apparently she testified in front of the grand jury. I mean, so at least she has some. The woman is cooperating in some way with the prosecutor. No.
That may be, but you'll recall, and I'm sure you will, that about 6 or 7 weeks ago, she put out a statement saying, "I just want to be left alone. I want people to respect my privacy." That's before she was ever brought to the grand jury or ever interviewed by one of the private investigators that the circuit attorney hired to handle this case. That was long before any of that. She wanted to be left alone. She was begging for her privacy. The fact of the matter is this case being brought is what really invaded her privacy and is going to make her come out in public. If the case goes that far, she's going to have to testify in open court. I mean, this is the thing that is really invading her privacy, not what she did with Eric.
Well, assuming there was no picture, if there the only daylight between your client Eric Greitens' story and the story the ex-husband's telling through her or around her or with the prosecutor is, one, the picture, and two, the reason, right? The governor has said no blackmail. Everything was consensual. So
right.
Whether or not there was a picture, and then whether or not the reason, whether it was for pleasure or for blackmail, that's really the only difference here in the two stories.
And once again, that's not even an issue. There's nothing in this case about did he threaten her, did he not threaten her. There's nothing in there about that.
But you say the picture doesn't even matter.
No, definitely not.
Because if there were a picture that were taken, well, if there were a picture taken and it wasn't consensual, you're saying she doesn't have any right to privacy because she disrobed willingly.
Yes, for sexual purposes, that's what this statute says, that you don't have a reasonable expectation of privacy with someone else, that you know you're taking your clothes off and you're being viewed in that setting. You don't have a reasonable expectation of privacy. And it says, that you have to be able to disrobe in privacy without being concerned that the person's undressing was being viewed, photographed, or filmed by another. And the statute actually defines views. And views is the looking upon of another person for the purpose of arousing or gratifying the sexual desire of any person. So that's what the legislature meant here, that if you're undressing in front of somebody for sexual pleasure, you cannot be prosecuted under this statute. That doesn't mean you don't have some legal rights, but this statute simply doesn't apply.
What do you make of the story that came out the other day of this client from Al Watkins who claims that he pled guilty to this same exact thing 20 years ago?
Yeah, it's funny, actually, because that guy was charged with child pornography, abuse of a child. I mean, it was a very, very different case than this, and most importantly, it was under a different statute. What he did, there was no viewing in that statute. It did not talk about a reasonable expectation of privacy without being concerned that the person's undressing was being viewed. It just said that you weren't concerned about being photographed or filmed. So the law changed. So Al is always entertaining, but not very precise if it doesn't help his position. And he got the Washington Post to write a big story about that, which was surprising. They're a former client of ours, and you would have thought they'd be more careful and maybe read the statutes themselves and see that this guy had been charged with child pornography and a lot of other offenses, and that the statute was totally different.
From what I understand, though, he only pled guilty to this invasion of privacy. Are you saying that invasion of privacy guilty statute is different than the one Eric Greitens is charged with?
Yes, exactly. That changed in 1997, and his conduct was, at least some of his conduct was before the statute changed. And the statute changed by the legislature added the word viewed. So, to have a reasonable expectation of privacy, that you can disrobe in private without being concerned that you're being photographed or filmed, is what that said.
So let me take.
It says viewed, photographed, or filmed. So it really expands the defense that if you and makes it obvious by the clear wording of the statute that if you're doing it the way this was going on, there's no offense.
Take it out, Ed Dowd with us, Eric Greitens, attorney, nice enough to join us for a couple more minutes. So take it out of this highly charged Eric Greitens story and take it to a hypothetical. So you have two hypothetical people here in the state of Missouri who consensually decide to get together. One of them decides to take a picture. The other one says, no, please don't. Your argument is that that person who says, no, don't take a picture, has lost their expectation of privacy between those two and the privacy of a home or a room or a private room because they chose to disrobe consensually.
I'm not really saying that. I'm saying that this specific statute doesn't cover that conduct. If there are other laws that do, I don't know. I'm sure that you could file a civil suit based on that and try and recover. Or even get an injunction, destroy that picture. You have some legal remedies, but all I'm saying is that this statute, the way it's written, does not cover that conduct.
Ed Dowd, I'll ask you one more time. Is there a photo from that original night?
Like I said, McGraw, I can't get into that now. It's too involved in trial tactics and strategy. But I can tell you, we want a trial because Eric Greitens, the governor, will be acquitted at that trial if the case isn't dismissed by the court before then. And we want a trial soon. We're actually going to be in court this morning at 10 o'clock to discuss the trial setting, and the circuit attorney is going to try to delay it, and we're trying to push it forward.
Oh, okay. So more news coming out later today then, I'm assuming.
Yes, 10 o'clock.
Mr. Dowd, you are always welcome here. Thank you for your friendship throughout the year, and thanks for your time today.
McGraw, thank you. Appreciate it.